Kia ora everyone, nau mai, haere mai, kia koutou katoa. Welcome to the hearings process for the Waikato Regional Coastal Plan. Just before I introduce myself and the panel, I just want to hand over to Mr. Rice, who's managing the process, just to go through health and safety issues. Mr. Rice.
First of all, if the fire alarm sounds, basically follow this. I'm meeting out at the car park and right hand side, straight out the corridor now. If that is blocked by the fire, we'll go out through reception to the left and out from there. Got a cell phone, can you please be on silent? No calls in this area if possible. And finally, toilets to the right, down the end of the corridor on the right hand side.
Thank you very much. Thank you everybody. Can I just introduce the panel to you? On my far right is Vicky Morrison-Shaw, Stuart Kneebone, Warren Marr and Hugh Lear-Snyder, and my name is Greg Hill and I'm going to be chairing the hearings. Mr Kneebone and Mr Marr are councillors, Waikato Regional councillors, but they're not here in that capacity. They are here as commissioners. I just want to make that point clear. I'm not sure whether there are other submitters here. I think it's probably mainly council staff here who will know that, but this has been recorded. And for those people who are submitters, I just want to make that clear. So just be clear that they are here not in their politically elected roles. They're here as hearings commissioners, the same as the rest of us. Our role is to hear the council and hear submissions and make recommendations back to the regional council in relation to those submissions, whether they should be accepted or accepted in part or rejected, and our recommendation on the coastal plan. The hearings have been scheduled for the next few weeks, and that's all up online. The hearing schedules, certainly up until week 4, are all published, so hopefully parties are aware of that and can check the website. Just for Form 2, there is the panel has an interests register, just where we have declared if we have any particular interests. Any party who wants to see that, I'm not sure if that's on Ms Somerville here, whether that's on, is that online, or is that if I'll introduce Ms Somerville in a moment. That can be made available. If any party requests it and wants to see it, that can be made available. Right, thank you. Can I just, to introduce, I'll get the council team, the Section 42A team, to introduce themselves when we come to that. But Mr Rice is effectively here managing the hearings process. Anybody with questions about the hearing and hearing process, please see Mr Rice. Mr Stu Rice here is running the technology. I just want to acknowledge Ms Somerville and Semi Thorogood. Is it Thorogood? Thank you for all the work behind the scenes. There's a huge amount of work to organise logistically these hearings, so thank you for that. Just in terms of those people who are not familiar with these processes, and there is a lot of material to have got through and people to have read it, basically what will happen is that the hearing panel is going to hear today and maybe first part of tomorrow from the council officers. We're going to hear from their legal counsel and the Section 42A experts about the process where we've got to and mainly the matters which are still outstanding. So I want to make it clear that the council's position is that which will be outlined by legal counsel. The experts, the 42A experts, are representing or have given their expert opinions on what they think should occur. And then once we've heard from the council officers, we'll move into hearing the submitters, and there are both there are submitters with expert evidence and legal submissions, and there will be non-expert or lay submitters, and we'll need to hear and consider all of those matters. And once we've heard from the submitters, the council then has an opportunity to reply to anything that's come up in the hearing in relation to what submitters have put to us, matters that have been raised by the hearings panel, and we'll come to that, but I imagine that will be done in writing sometime after the hearing, so it'll get concluded probably a few weeks after the hearing, but we'll come to that later in the process. The hearing panel has done some site visits. We spent 2 days on the east coast in late January. We're yet to go to the west coast, and we'll look at a suitable time to go and do that if we need to do that in relation to submissions. So we are broadly all familiar with the spatial extent of what we're dealing with and a number of the issues which are before us. We have read all the material that's been presented to us, the plan, the Section 32 evaluation, the submissions, the 42A reports and their addendums, the evidence and the joint witness statement. So what we're going to be asking council officers and experts and others is that they don't need to read their evidence. Really what we are seeking is sort of high points, executive summaries, and then we'll go to questions. I think that's a far more efficient way of dealing with the matters. If we had everyone read all of the material, we'd be here for an awful long time, and we'd probably all be asleep. So I don't think we'll need to do that. And just on that, I really want to thank, on behalf of the panel, the council officers in terms of the 42A and the addendum reports. They're very comprehensive, and they've clearly set out where those experts have got to. Equally want to thank the submitters and the experts who have been involved in council in the expert conferencing sessions and the joint witness statements that have come out of those. They are all available online. That's clearly evidence before us. It appears to us that a number of the issues, or quite a number of issues, have been at least narrowed and a number of them have been resolved. There are still clearly some issues outstanding in contention. Mr McAuliffe's clearly set those out in his statement and clearly coming through in the reports. Again, the panel questions and does really want to focus on those matters which remain in contention. It seems to us where matters have been resolved, we're satisfied with those. We're unlikely to undo that. Of course, there are a whole range of non-expert submitters who may have views on where the experts have landed. We'll need to clearly and diligently consider those submissions to see whether that changes the position that those experts have had in our mind. So I just want to make it clear too, so lay submitters are not disadvantaged in the sense that we have expert evidence before us, which we will solely rely on. We are reliant on expert evidence, but it's not the complete picture. So we will be hearing from lay submitters at the same time. Just in terms of logistically breaks, we'll just find suitable times to take breaks. We'll probably take a break somewhere later this morning just to have another, I'm not sure there's another cup of tea. Lunch will be around about 1 o'clock, afternoon tea if we need it around 3:30, but we'll just find convenient times to stop. So can I just check in anything else from any other party? Just, is there anyone here who's unclear on process or has any questions about process, logistics, roles, responsibilities? Nobody does, thank you. Then I'll hand over to, is it Mr McAuliffe going first and then legal counsel? Great, thank you. Thank you, Mr McAuliffe.
Okay. Morning, everyone. Perhaps for those that don't know me, I'm Bruce McAuliffe. I'm the manager of the Resource Management Policy section at the Waikato Regional Council. Great.
Can people hear Mr McAuliffe down the back? Is the mic's working fine? Great, thank you.
Okay. So, take my statement as read. My statements on behalf of WR's Waikato Regional Council as proponent, and the purpose of it is to provide context for the hearing and outline the development of the proposed plan, its content, and the key matters that are remaining in contention. So in my evidence, I go over the development of the proposed plan. We started developing that in about, if I remember correctly, it was 2019. We went through a substantial development process, including engagement with iwi stakeholders and public, and including specific landowner engagement on the maps around significant natural areas. So, also my evidence is the section on the decision not to impose coastal occupation charges, which we're required to do by the RMA, and Council did consider that issue. I also go over the submissions received, taking it we did notify this plan back in August, 18th of August 23, and we received something like 1,359 submissions, which the majority of those were pro forma submissions from Legacy. There were 107 actual submissions. So my evidence goes through all that, the matters raised in those submissions, and covers the expert conferencing, which the panel directed us to do, and which was very beneficial. So I also cover in paragraphs 104 and 106 the matters that are remaining in contention following the expert conferencing and the evidence that we've received. So some of the key matters that remain in contention, perhaps around aquaculture. Some of the energy and infrastructure provisions are still in contention, but also matters around the control of fisheries, and there's quite a lot in that you'll hear about that, I understand. There's also other matters include ecosystems and indigenous biodiversity and provisions around those. And there are some general matters also that remain, which are listed. So it's a very quick whistle-stop tour of my evidence.
Thank you. I'll ask a question, but again, your overview was very helpful because it really did sort of set out the state of play about where it's been and where we're at now, which was very helpful, so thank you. So, any Ms. Marston-Shaw questions?
Morena. Is my microphone working? Just at your paragraph 20 of your statement, you referred to a couple of high-level legal reviews having been undertaken pre-notification. Got that paragraph in front of you? I was just wondering whether, by referencing them, you are expecting us to take those into account. I don't think they're before us, or whether you were just pointing out the background for that.
We're just really pointing out the background that we've actually been through a very thorough process in development of the plan, including legal reviews.
Right. In your paragraph 24, you refer to an implementation guidance document, and just wanted to clarify, the intention is that guidance document would sit outside the plan, it's not intended to be referred to in the plan?
That's correct, and it'll be prepared once we've been through the entire Schedule 1 process.
Right. Paragraph 26, you talk about te tiriti, and you state that the proposed plan does not affect claims for customary rights and interests. I just wondered, are there any customary marine title orders or protected customary rights orders that have been issued for this rohe?
Not to my knowledge, they haven't.
Okay. Right. And then in terms of the statement that it does not affect those claims, if activities are being proposed as a permitted activity that were previously requiring a consent, it would affect those claims, wouldn't it? And that there would no longer, if a permission right, if a customary marine title order is subsequently issued, my understanding is then there would be a requirement for a permission right. But if it's a permitted activity, then there would be no requirement for a permission right.
That's my understanding, yeah.
And so you don't see that as, are there any examples of activities that may have been changed through this process to become a permitted activity that weren't before?
Not that I'm aware of, but my colleague. David Sinclair might be able to assist me with that.
Just on, if you don't know the answer right now, I'm happy for you to come back.
Yeah, if I may, Mr.
Yeah.
Chair, yeah, because I'm not.
Yeah.
I know there's some
Yeah.
proposed.
Well, let's pose that a question if you could come back to in response to Ms. Morrison-Shaw's question. Are there any permitted activities which you think might actually impact or would impact on those MECA claims?
And then just on that topic of MECA as well, later in your evidence you talk through the background of who was consulted. I wondered whether the claimants within this area were consulted as part of the process.
Yes, they were.
You just didn't specifically mention them, so that was why. Just double check.
Sorry, Mr. Chair, just to clarify, Morena, Commissioner, ko te pasakli toku inoa. Just to clarify, we did, or the council did send letters to all of the MACA claimants. Of course, the emphasis, I guess, was on them, whether they wish to engage or not. And you'll see through the process that's been outlined in Mr. McAuliffe's evidence that there was engagement with mana whenua. However, in some cases, the coastal plan wasn't a priority for mana whenua against other priorities that they may have. So we very much did, through both the draft plan and the pre-notification plan, try and engage with those MACA claimant groups.
Thank you. That's all I had. Thank you.
Thank you.
Yes, thank you. Thank you, Mr. McAuliffe. Very comprehensive statement, thank you. Look, just a question on your paragraph 51, and it's something that that we might hear more about, but it's in relation to individuals who own part of this, part of the seabed, part of the CMA.
Yeah.
And in particular, I'm thinking about the waterways on the east coast and those areas that have been declaimed, and whether the effects of sections 12.2, which are around the occupation issues, whether there are any of those submitters raising issues around the matters of occupation as distinct from the 12.1 matters, which are around the activity of the dredging or whatever it is, and the use matters. So there's distinct wording differences between 12.1, 2 and 3, and that 12.1 talks about the coastal marine area, 12.3 talks about the coastal marine area, and 12.2 talks about the common marine and coastal area, I think.
Yeah.
So just, has that been an issue that's been raised in terms of the rights that people might have of the land that's been owned, that they own?
I'll need to come back with your specific
It's
answer
very
on that.
complicated.
Sorry, I need to talk to the team about that and look at the submissions quite carefully.
No, absolutely.
And get some comment on that, if you don't mind.
Thank you.
Perhaps, sorry, Commissioner, just to add, we haven't had any submissions that have specifically raised that issue.
Okay.
However, I understand the nuances under Section 12. Clearly, the waterway canal developments are common coastal marine area, and there are other areas of private land that were identified. And as set out in Mr. McAuliffe's evidence, the landowner engagement that occurred was with those landowners that held private marine title within the CMA.
Yes, and none of those were people who had waterway properties.
No.
Okay. In your paragraph 77, talk about occupation charges, personal occupation charges, and the last sentence there says there are also legislative and other barriers to implementing effective coastal occupation charging regime in the region. And I just wondered whether you might be able to elaborate on what you saw as those legislative impediments.
I think it's probably a legal question.
I'm happy for your counsel to help us with that too.
I would need a bit of help with that question.
Yeah, no,
Excuse me.
absolutely fine. Your paragraph 94 goes to the issue of fisheries management. It says this is on the basis that central government actions proposed as part of the revitalising the Gulf strategy, achieving similar outcomes, using more appropriate tools. So my question is, although there are separate legislative processes underway, does that restrict the council from taking action in these matters?
I think the position of the council is that prefer not to take action at the moment, bearing in mind what the central government is doing, which we don't want to double up on any restrictions that may or may not occur, and thereby requiring double consenting or, of issues. That's the way I'm viewing it. We don't want to put too many impediments in the way. Central government does have a process which they're working through, and we'd like to see the outcomes of that first.
Thank you. Thank you.
Mr. McCall, I've got a couple of questions, but they're sort of broader ones, which you may need to defer to the rest of the panel. Yeah. It really goes to whether the council's position is that further expert conferencing or other mediation might be helpful, and I'm thinking potentially around those matters which are still in contention. Say particular focus on aquaculture, but probably more so this issue, well, I just call the fishing issue about the controls. Environmental Defence Society, as you'll know, have got quite strong submissions and evidence about why the plan should include those. And the council's position is, and again is set out in the Section 42A reports and the addendums about why the council's taken the position it has. Of course, the panel's going to have to make a call on what it thinks is the most appropriate course of action, whether it agrees with EDS, whether it agrees with the council or something else. And again, we'll come back when we deal with legal submissions about some process issues here, but would the council be open to further considering that within the bounds of this submission process? We'd need to set that up.
Yes, we would be open to.
Right, okay, right. Yes, so we'll explore that a bit more as we get through it.
Yeah, if
right.
we need to, we will.
Thank you very much. Thank you. Just anything further from Mr. Hall? No, thank you very much. Okay. Very helpful.
Thank you.
Thank you. Mr. Conway, is it?
Yes, good morning all.
Good morning.
Matt Conway for Regional Council. Now, yes. I understand you have and you have read my legal submissions, and I'm not planning on taking you through them. I think that's probably in everyone's interest not to hear me read them out. So I'm in your hands as to whether you would like me to step through and briefly touch on different sections in there, or whether something even more high level than that would be useful as a starting point.
Thank you, and first of all, thank you for pre-circulating them. It's very helpful when parties pre-circulate it. We try and insist on it, but of course we can't compel it. Most people, council, comply these days, so it's very good. Thank you to have that. I think if we could just sort of step through topics, and I was just talking to Ms. Morrison, I think we might ask you questions at each section, might flow better. So if you can kind of, there are a few key issues, and there are a number of issues in there, but a few key ones. So happy for you to step us through, and we'll just check in with questions at that point.
Yes, that sounds good. And yeah, please do speed me up or slow me down as needed on the way through. So the goal, just thinking in terms of the introduction, I've set out there the topics in 1.4 that I cover. The first few of those sections really are I probably call them boilerplate sections, the framework endeavouring to have all the parameters for the decision set out in one place. So I think those parts I will step through very quickly. And then I go on to some other parts that are more geared to some of the legal components that underpin the points of dispute in some situations. As a general overall comment, I would say there don't appear, in my view, to be too many of the submission points or matters in contention that have necessarily a strong legal component to them. A lot of them are policy calls and evidential calls, but there are some where I guess making sure that you're aware of the most up-to-date case law, and I'm conscious you'll have a pretty good handle on that already, is useful in terms of what you weigh and how you test the different components. And so we've endeavoured to set that out in a way that is helpful for your process. Turning through to part 2 in terms of the section 42A, reports and evidence. Just to note, as a bit of an introduction to what the officers will say soon, when they come to their presentations, in general, the officers have endeavoured to present an updated position where it exists, reflecting their review of the evidence that's coming from submitters. The one exception to that I'm aware of, and there may be others, is with aquaculture. I think submitter rebuttal evidence is due at midday today, so for obvious reasons that hasn't been able to be done, but obviously to the extent that other things come out through the hearing, and likewise in terms of matters that come out during the hearing, for me, we'll cover that off in reply. Stepping through to part 3, that really just sets out an explanation of the Waikato Regional Council and its role and functions, and then part 4 steps through that statutory framework and is summarised away, as I thought would be helpful and clear. There are some specific documents, including the Hauraki Gulf Marine Protected Areas legislation that I've noted in 4.3, just because it alters the situation in relation to coastal policy statements. Essentially, that parts of that act sit there as specific coastal policy statements. Then step through the requirements for regional plans generally. In 4.10, I would just note there's water classes specified in Schedule 3 of the RMA. Those were disapplied to freshwater in 2017 when the National Objectives Framework came in, but they still apply to coastal water. So in case that's helpful, that's a small interpolation there in terms of what I've said. 4.13, and in a few different places, I have noted some upcoming anticipated legislative change. Now, I do that with some caution because I'm conscious as soon as we start thinking about legislation that's not yet passed, it's easy to get distracted into it, including for myself, out of curiosity. But as you'll be, I think, aware, the legislation that as it stands at present is all you can take into account. So this is really just for context, and I think the way it might come into your process is if any of that upcoming anticipated legislation passes by the time of your decision, then you'd need to look at that point as to whether that alters your decision framework for this process or whether there's some transitional provision that means it doesn't, and that's something that I think we can test and provide advice on at that time if that's necessary. But other than that, this is simply there for context.
It's always a slight nightmare scenario for commissioners when you're going down a particular path and then things change, like national policy statements change and legislation change. I'm just going to say to the panel, just ask questions. Don't wait for me. Right.
Yeah, so just on that one, I understand from the evidence, our decision's due by August at the latest. Has there been any indication of when that bill might pass, firstly? And secondly, is there any indication in the bill that there will be transitional provisions that it won't apply to existing decisions? Or is there a proposal that it might be retrospective? I know that the government has introduced some legislation of late where they have proposed a retrospective component. So just interested, in terms of crystal ball gazing, what can you advise us at the moment?
Yes, no, good questions. In middle of this year is the indication of when that bill is expected to be passed. The same applies, as I understand it, for the policy, national policy statements and the refresh of those, which is again unhelpful in terms of this process. And it seems there may have been some delays in the national policy statement update work, because I'd anticipated we would have seen those by now. And I haven't seen them. Some in the room may be aware if there's working groups happening, but in terms of transitional provisions, I haven't specifically checked that in the bill, but I will do that, and certainly if we have a pause for a break, I might be able to come back to you on that today, to just check what those are. Often for consenting, there's a very clear transitional provision for planning documents, though on some aspects it simply applies as and from the date it gets passed, and so that would be more problematic. But maybe that comes out in the wash.
Thank you.
Stepping through this further, section 32 requirements will be well known. In 4.7 and an ongoing, I talk about Te Ture Whai Mana. Now that's obviously of much more significance for freshwater management scenarios. Here, as I've said in 4.20, it is relevant for the part of the CMA right down by the Waikato River mouth. And the way that plays out in the proposed coastal plan is through some integrated management provisions where there is specific reference to Te Ture Whai Mana. So rather than get into specific rules and the like that impose particular Te Ture Whai Mana related requirements, it's in there as a policy and objective directive, so that when those provisions are being considered through any consenting process, they can be looked at in that context.
And that's the approach that's been taken with the integrated management with the sort of coast terrestrial environment as well, isn't it? In that there's been policies and objectives for integrated management, but no rules regarding activities above them.
Yes, that's right. The intention is that this would sit there and be able to be applied across that boundary in terms of policy direction, but it's not endeavouring to manage any activities through rules outside the CMA boundary.
Just on Te Ture Whai Mana, as you'll know, a number of us in the room have been involved in Plan Change 1 to give effect to Te Ture Whai Mana. I know it's before the court, but correct me if I'm wrong, I don't think there is any sort of philosophical disagreement about how it's to be given effect. Well, it's not quite right. How do I say this? Is it likely that a court decision will upset the whole approach to how Te Ture Whai Mana was to be given effect to in Plan Change 1, which then would translate into a different management framework in terms of the coastal plan? Do you know that?
Not that I expect. Certainly through the Plan Change 1 process, there was a high degree of acknowledgement and recognition of Te Ture Whai Mana, and I think that's played out in that process in a way that we should hopefully see some useful guidance to the extent we can when that decision comes out. I'm anticipating that too, but I'm not sure exactly what the timing is for that decision. I understand there's also a review of Te Ture Whai Mana that's ongoing, but I don't have a particular status update on that, and obviously it's the current version that is the one that's relevant for this process in any event at the moment. Stepping through further, in part 5 I go on to talk about avoid directives, and this is where some of the case law really comes in, and it may flow through to some parts of your process. And there's been a wee bit of maybe a weaving path for what avoid means and whether there's an overall balancing of those sorts of things over the last 30 or so years. King Salmon came through with a fairly strong directive that, favourite quote, avoid means avoid. but in more recent years, through the Port Otago litigation and more recently with the East-West Link decision, I think the Supreme Court has overlaid that with a perspective that says, well, there may be deserving exceptions, and there may also be some policies, including within the NZCPS itself, that need to be read alongside each other and are all strong. So, for example, in the Port Otago decision, there was a specific ports policy, and that had wording that wasn't a void. It was, I think the words were recognise and ensure and that kind of thing. And so the court essentially said those are directive words too, and you can't simply say that one policy directive will always override another, and you need to carry out a structured analysis. So that case law, we've set out what we think to be the most useful parts of that to orientate you in that part of the legal submissions there. And I'll touch on some connected points a little later on when it comes to the National Policy Statement for electricity transmission, because it does arise there, and also in relation to regionally significant infrastructure.
Are there other questions on the avoid? I've got a couple I'd like to that avoid becomes highly significant, clearly, in the coastal marine area, given the policies in the National Policy Statement. I'm not a lawyer, but as I read the jurisprudence that's come out, so in Port Otago, kind of seemed to shift that avoid away from that kind of much more clear cut in King Salmon, which did talk about not causing material harm, and also talked about you can mitigate to an extent that the effects are effectively avoided. And then East-West comes along, and again, I'm not a lawyer, but reading, I thought it was quite an interesting decision, because it sort of started to introduce the word balance again, and things that you have raised in your legal submissions. And then, and I note that Ms. Turner for EDS in her legal submissions, I don't know if you've read them, refers to Justice Glazebrook's sort of dissenting view in East-West, which in my reading tends to sort of, and it's a dissenting view, but takes it back more to a hardline King Salmon view. So what's your submission to us in terms of where do you see the avoid issue lies? Is it in terms of that Port Otago view that it is around not causing material harm, and it is about appropriate mitigation to the extent that the effects are effectively avoided? Where do we go with it?
In terms of the case law that's there at the moment, the majority view is generally the one that you apply, and so to the extent that there's a minority view, I guess that helps test what wrestling has happened on the bench through particular decisions, but it's the majority view that is the one that has carried the day. Naturally, the nature of the way these things play out in practice is that there is a specific local factual context for that wrestle that's happened in each of those cases. And I think what seems to happen is the court looks at it and says, well, what does the legislation mean? What does the national policy direction mean? What guidance can we provide about how to apply it in this current context? And a lot of that relates to the specific wording of the specific policies and what comes into play there. I think the clear direction of travel from those two recent decisions has been that you need to be careful before you apply an approach that is too absolute, because even if the word balance is a tricky one and there's been a move away from this overall broad judgment approach that used to be applied,
some of us love that.
There is still a recognition that these are judgment calls, they are, and they're interpretation calls, and And I think it needs, at these points of the decision process, you need to slow down and step through what's the consequence of taking an approach that's that strict. Can we find a way to rationalise something where we can genuinely say we have assessed and appropriately applied both or all of these relevant policy directions? And so that's when you start looking at all the detail and the wording about, well, how rigid is that, and is it possible to come up with an interpretation that means it's realistic to apply it as well? So that's a long-winded answer to a question, but it's a very good question.
Thank you. It's helpful. Thank you.
Now, the part 6 of the submissions, I touch on the jurisdictional boundary for the plan, and it is the coastal marine area in terms of the rules. I'd noticed when I was reading through these again this morning that I've got a typo in 6.8, and the second sentence there. The first sentence confirms the rules are focused solely on activities in the coastal marine area, and the second sentence, I say CMA again, but it should be CE, it should be the coastal environment there, because I was thinking about the landward portion of the coastal environment being the part outside the coastal marine area, but still within the coastal environment. Hoping I haven't, by trying to clarify that, confused the position further. But essentially, the rules stop at the CMA boundary being met in High Water Springs. And we've already touched in terms of the earlier discussion on the points in 6.8 about those integrated management provisions. Likewise, in 7, I just touched there on what that means around river mouths and the agreement there in terms of how the river mouth is defined, and it refers there in section 7.3 to section 2 of the RMA and the way that definition applies. In part 8, I touched...
Sorry, just before you move on from section 7. In section 7.6, you reference the section 42A report of Ms Richardson and says that she considers that it's consistent with the boundary layout, although she recommends an amendment to exclude the Whiritoa lagoon. I guess my question for you is, there's no legal issue in making an amendment that go beyond what's set out in the agreement, and where is the limit to such amendments, i.e. when will they become inconsistent? We obviously don't have the agreement that you're talking about before us, so is it something that we need to have regard to? Does it provide for amendments, or is it a hard and fast line?
No, that's a logical question. My understanding of the situation in relation to the Whiritoa lagoon is that, and I may need to come back to it with the specifics, is that the agreement isn't necessarily specific in that location, but if I can come back to you on that, I will, just to make sure it's clear, because it's, as you say, if we're sticking to that agreement, we want to make sure that we're sticking to it on all locations. But I understood there was some variation there that was using a straight line approach that did enable some clarification. Now, Mr. Sackley's nodding at me there. I'm hoping that's a nod to the substance, but if there's an update on that, I will endeavour to come back to you on that position, or otherwise Ms Richardson may be able to confirm the position.
Mr. Visantia.
Yeah, just through you, Chair. We have obviously Ms Richardson here and State as well, who can clarify that, but the understanding is correct. From an ecological perspective, Whiritoa Lagoon is clearly salt water. However, because it's not part of that original agreement, in terms of the interpretation of Part 2 of the RMA, it means that it's been recommended to be excluded. But that's something that Ms Richardson could touch on further in her opening presentation.
Thank you.
Turning to regionally significant infrastructure, as I've said there, the definition that was initially in the proposed plan was essentially it was exactly as per the RPS, and I've set out there some explanation for why that inclusive definition has been agreed to be modified by the officers through this process, and really they've endeavoured to do so by way of testing that it still gives effect to the relevant objectives and policies, and that any amendments to that definition are in line with that RPS and not somehow deviating from the intent. And I think this is always the challenge when you have a definition that lists particular infrastructure and then other infrastructure may be pointed out, and they've sought to strike an appropriate, if I can use the word balance again, in terms of what particular items should be in or out. But I think there is still some dispute about that from submitters that you'll no doubt hear about.
Just in relation to that, so obviously we've got this definition which says, this includes, and then it has the list. And you've, in this section, referred to some case law and then said, basically because it's an inclusive definition, you can add in additional things. Is there any specific, because the case law you referred to is basically king salmon, but that doesn't specifically, that issue wasn't before them in terms of adding to a list. Is there any case law you're aware of where that issue has been before the decision maker and they've confirmed that where a definition is worded like that and has a list, you can add to the list?
Nothing that I think I would have noted it in there if I'd come across it, and I haven't. So I think that means that we didn't find any when my team was having a hunt through. But I'm sensing you might be aware of something that I should be aware of here.
I'm just thinking that there was maybe a fast track decision, not that it's a binding on us, but I do recall that the issue arose in the context of a fast track consent under the COVID legislation, where there was a specific legal opinion which was sought on that, and they made a determination in their decision about what was regionally significant infrastructure. And I guess if that is the case, if I'm remembering correctly, I'd be interested in your submissions as to what weight we would have give to a fast track decision.
Yes.
On that particular issue.
Thank you, that's really helpful, and I will look that up, and I'll endeavour to come back to you on that.
So, sorry, just to clarify, I think you're referring, Commissioner, to the Kopu Environmental Protection Agency decision on the Kopu Marine Precinct. So the panel in that case did get its own legal opinion around the issue of whether the RPS definition was absolute or exhaustive. That differed, as I understand, from the legal advice provided to Waikato Regional Council. However, it's something we have looked at, not with Matt, but with his colleague. So if we could just come back on that and just respond to that more fully, I think that will give a bigger picture or a wider understanding. It is touched on in the addendum report, again, of Ms Richardson. It does refer to that Kopu EPA decision, as well as Ms Yang in the energy infrastructure addendum.
Thank you. Great, thank you. That's helpful. I will test that with Mr Sackley and go from there. Part 9, I'll touch on the functional need versus operational need matter, really to set out what those definitions are and the way it works. Naturally then following on from what those definitions are and how they work, there is a question in each case as to whether a particular provision should refer to functional need and or operational need, in various forms. And so that I think is really where the discussion sits, as far as I'm aware, in terms of what submitters are seeking. They're really seeking some adjustments to the way those are used in different situations, and that then becomes largely a policy call as to which approach is most appropriate, noting that some of the national direction uses a specific phrasing, and then that obviously needs to be tested in the particular provision.
Yeah.
Just on that, and it's not a question at this stage, but I did note when I was reading through the provisions, there generally I think it was functional and operational, or functional or operational, but there was one instance where it used the other, so it was like or versus and just was wondering if that's a typo or whether it was intentionally different. So just putting that out there for officers to go back on.
Great, that's a helpful signal, thank you. Moving to the question of lawfully established in part 10 of the submissions, there has been a change to the way the plan has used lawfully established versus existing lawfully established and authorised. Really, it's a simplification to bring it into hopefully helpful alignment with the terminology that case law has been reasonably clear about defining. And so we've just explained that there.
Just in relation to that, with your para 10.4, you say that the plan doesn't currently include a definition or guidance on lawfully established. Was that requested by a submitter, that there was a definition?
Exactly, Mike.
I guess from a legal perspective then, is there any drawback to including a definition of lawfully established in the plan? And if so, could you talk us through what that might be?
In general, the approach that I've tended to advise when words have been defined or explained by case law and that's reasonably settled is that there's no need to define that term, and particularly if that meaning can change a little bit or be refined over time. In some instances, I think it's better to allow that to occur without then having a definition that might get out of date. But I appreciate there are pros and cons, and in some cases it may well be that a definition assists. So that, I think, then becomes a judgment call as to whether there's plan workability. It's preferable to have one, but certainly I don't think there's a need to, given that the case law seems to be reasonably clear about what it means. As I say, that's more of a policy call, I think.
Sorry, just in response, Commissioner, Royal Forest and Bird Protection Society did ask for a definition for lawfully established. The officer's position at the moment is the reason set out by Mr. Conway that such a definition isn't required. I note that the submitter didn't provide a definition, they just requested one, so it may be a matter should they appear before the hearing panel. I think they are on later in the hearing. Maybe a valid question, or they may wish to address that. They didn't take part in expert conferencing, so it wasn't a matter we could actually address directly with them. And they haven't filed evidence either, so we're a little bit unknown as to whether they do have a definition.
Turning to the question of fishing controls, and the Chair's mentioned that, it's come up already today. That is a policy call that has been made. I'm conscious there is case law around this. A couple of cases we've referred to in our legal submissions that talk about the way the courts wrestled with that question in the reasonably recent past. And in 11.3, I think I've endeavoured to make it clear what I think those cases were covering and what they weren't. And in no place in any of those cases can I see an indication that a regional council is required to control fishing in its regional coastal plan. Naturally, the functions that come up are the ones around biodiversity in section 30. And the meaning of those was being tested in some of that case law, and in particular in the Ā-Rohe Trust case. The question was really about the effect of section 30 subsection 2, which is that limitation to say a regional council can't impose certain type, or can't apply its function in certain ways for Fisheries Act purposes, because the Fisheries Act regime is sitting there with a particular goal, and it's not the place of a regional plan to step into that space. But there's naturally, just like integrated management generally, tends to lead you to a situation where there's overlap. Here there is overlap in what the Fisheries Act is seeking to do, and perhaps what the regional plan under the RMA is endeavouring to do. Yes.
On the fishing, I do have a few questions, and the first one was really, because you just mentioned the case, and scope, and you've made the point that they can include, but they're not required to. In this particular case, there's a request from EDAs for fishing provisions to be included. They made that request in their submission, but they didn't provide the text of what they were wanting in terms of rules or policies in their submission. They have now in the evidence. And there's no Section 32 assessment at that stage. So I'm wondering, is there jurisdiction, is there a scope issue here? Are we, if we're looking at Clearwater, motor machinists, those types of issues, are there any issues there that would stop us from being able to consider the substantive issue about, is it a good idea or not to include fishing rules?
Thank you.
Can I just round that up as a complete question, because it's the one I sort of put to Mr. McCaller. Given that we are going to have to deal with it, and it might just be a straight scope issue where we determine there is no scope, but of course we're not making that determination right now. If we did set up this alternate process because it's before us, we have to deal with it, to look at if there was to be a set of provisions to control fishing, what would that be? Get the experts to do that. If we did that and that came to us, in terms of the scope argument, how would we need to deal with that legally so that all the parties had a fair shot at it? So in a kind of, there's a broad realm question there. Can we do it, and if we do, how do we do it?
Yes, I'm conscious of the need to answer that carefully, given that the scope point could be quite significant. I think when it comes to the way a submission is framed, I've never understood it to be the position that unless a party provides specific wording, they don't have scope. If they've made the substance of their request clear so that a reader of their submission would be able to understand the nature of the relief that's being sought, then it can be within scope. The question is whether it is sufficiently clearly expressed what is being sought, that there is no procedural fairness issue. Likewise, in terms of Section 32 evaluation, if a submission has clearly requested a change, then the Section 32 evaluation can be done in relation to that relief. It's not necessarily the case it all has to sit in the submission itself, albeit that a submission is much more helpful if it explains the Section 32 rationale for the changes that are being sought. So I would be hesitant to say as a black and white matter that there is no scope here. I'd want to have a close look at that submission and the way it was expressed and test that a little bit further. And if it's okay, I'd like to do that before giving you any firmer answer on that.
I'm sure Ms Morrison-Shaw will probably ask Ms Turner tomorrow for EDS the same question.
Yes.
So again, we'll probably get a bit more information. I mean, I'm not going to put words to her mouth, but I'm assuming, given who legal submissions say we should include them, her answer is likely to be, yes, there is clearly scope. We've given you a clear indication of what we want. We've now given you evidence. But of course, as I said, there's a whole legal process here. So, and I'm happy for that to be a considered response, because I think this is probably one of the most significant issues facing us in terms of this. The plan has been quite clear why it hasn't. It's not including why it hasn't included it, and we've got submitters, EDS namely, saying why it should be. But of course, the implications of doing that are quite broad across all the commercial fishers. Recreational fishers will probably have a view, and others will have a view. So hence it is quite, I think, quite a vexed issue for us at this point.
Yes. And
I was going to say, I think it would be really helpful to have some detailed submissions on scope on this particular issue. I'm just sort of mindful of some of the case law around scope and the considerations of, have people had a fair opportunity to have their say? Is everyone that might be affected by fishing rule had a proper opportunity to participate through this process? Does the further submission process, in the absence of the detail of the rule, in the absence of a Section 32 report, does it put people on notice so that they've had that reasonable opportunity to participate? So I'd be really, I think it would be helpful if we could have some submissions.
Just to extend that a bit further, I mean, I think we should hear from Ms Turner tomorrow, and I don't know whether there could be a joint legal, I don't know whether you do that. I mean, Anyway,
We'll look to assist you with as much clarity as we can on it. I guess in the meantime, grappling with the merits of the relief that's been sought remains the focus, I suspect, and that way, depending on where you go in terms of merits, if you were to conclude that the merits don't support it, then I guess that takes the scope question out of play. If you consider they do, then naturally you'd need to make sure you're comfortable that there is scope. So there's different ways to look at it. But yeah, I'll test and see how quickly we can get a considered response on that.
Thank you.
And just a quick one. And does the term methodology come into this discussion or not?
Sorry, what do you mean?
The term methodology, because that kind of feels like part of it to me as well, in terms of how the environment is impacted.
Right. In terms of the way the provisions would play out and the rules,
in terms of the impact is perhaps it's not so much on the fishing itself, but the way in which the fishing is undertaken, as in bottom trawling license.
Well, yeah, as to what the specific controls are, the methodology of fishing may well be part of it. I'm conscious there are a large number of submitters, perhaps in the recreational category, who've expressed a view perhaps related to that. But yeah, it could do. So I guess it depends what the rule would regulate. Does it regulate all fishing? Does it regulate specific types? And the nature of the marine environment and the particular resources that are protected or not by this plan might determine some of that.
Mr. Conway, just while we're on your paragraph 11.3, my question relates to, it says here, the general and whole plan section, including section 42A report, including that the council does not have a complete data set of affected areas. And so, I guess my question is, from a legal perspective, is there sadly we live in a world which we don't know everything about everything, and so is there some sort of legal threshold that you're aware of, or is there any case law about the level of information that might be required?
Generally, the basis on which you'd proceed is to use the best available information. Where there is incomplete information, obviously you need to think about the risk of acting or not acting. If you don't have that information, that's in terms of the Section 32 test. Here, given that it's not a mandatory thing to have fishing controls in the plan, I think it's quite reasonable for the officers to look to have some data and information that would give them a solid basis on which to proceed before introducing these kinds of controls. And so that's why I think the provisions have focused more on these significant Indigenous biodiversity areas where they've been identified, because there is knowledge about those and knowledge about the types of controls that should occur in those areas. Whereas more generally, having fishing controls is a step that they'd want a bit more confidence to take. And to understand both the pros and the cons of including those controls.
Thank you.
So just one more question from me on the fishing topic. Just in your para 11.8, you refer to the bill again, so just adding to your homework about the if the bill did come in, is there a transitional provision, and if it is, bringing in those rules that say they must have been included at the time that the plan was notified, what happens then for our decision?
Yes, and I will check on that transitional provision, but the way I understand those requirements is that they're essentially designed to require that pre-step to have occurred, and this plan has passed that point where that would be possible. So if I can call it a reasonably confident guess based on this, which I'll test further, it's that this plan would struggle to meet those requirements in retrospect.
And if you could address whether, if those rules did come in, so the bill passes, what weight we should give to the fact that the law has changed, even though it's not binding on us, assuming that's the case, in terms of is it another reason, which we could say was for or against the introducing rules.
And I just wonder if I could add, and perhaps some commentary around Waikato Regional Council's submission on that bill, regarding around the fishing inclusion or not.
You'd like to hear some more about it?
Well, yeah, I know we have submitted on it as with my Waikato Regional Councillor hat on, but in this process, I think it'd be helpful that the panel hears what that council submission was.
Okay.
Thank you.
I'll check who's presenting that part of that submission.
Thank you.
Through you, Chair, that's easily achieved. I understand that. It's been made public in the last couple of weeks, with submission going to committee.
Thank you.
So that can be provided as part of Mr. Conway's response.
Thank you.
All right, moving to part 12, mentioned earlier, I'd come back to the National Policy Statement on electricity transmission. And this is a topic that arises around the country where there is a national policy statement in favour of the national grid that sits alongside national policy statements for things like the coastal marine area. And the officers have worked through with Transpower on matters relating to that, and there is more agreement now than there was. I'm not entirely sure whether that's resolved things 100% or whether Transpower still has additional changes that it wishes to make, but no doubt that'll become clearer. One of the reasons why this issue about avoidance has been coming up for a while, particularly in relation to electricity transmission, is that there is a phrase, seek to avoid, in the NPS ET, which has been causing us all to scratch our heads and try to make sure we understand it well. I think in reality, if you seek to avoid alongside avoid, there is a natural reading that seek to avoid must mean something slightly less strict. I think when I read the Port Otago and East-West decisions, it seems like the same kind of idea is coming through in those, that actually there are types of infrastructure, ports or perhaps roads in certain situations in terms of east-west, or in this case, electricity transmission infrastructure, where it's not realistic to always avoid. And that's why the officers have worked through and tried to make sure that the policies enable a proper assessment of effects and endeavour to seek to avoid certain adverse effects without specifically using that phrase, seek to avoid. So they've endeavoured to capture the intent while allowing for deserving exceptions. And I think, you'll no doubt want to and get to test the wording that they've used to do that, but it's I think it's a practical approach to try and get clarity in what's being meant. Part 13 there, talking about the NES for marine aquaculture. I don't intend to step you through that in too much detail, but essentially it comes down to that point in 13.4 where the RMA leaves it to a national environmental standard to determine whether rules in a plan can be more or less stringent. And there are some differences in different clauses in the NES for marine aquaculture as to whether they allow that or not. And so as you're applying each of those relevant clauses, there's the fine jar getting used again. When you look at each of those clauses and the specific relief that's being sought by some submitters to change things like activity status, it is helpful to look back at the very applicable NES clause to make sure that you're comparing it with the wording as to whether it allows more or less stringent. Sorry, that's a long-winded way of saying it depends on the clause. And if, and I just say there in 13.4, if it's not quite a prohibition on having a rule in a plan that is more or less stringent. But my reading of it is that a more or less stringent provision would be ineffective, essentially, because it's the NES one that would trump the position. And then finally in 14, there is just a note there in terms of the application of general standards and terms which apply across the board as opposed to on specific topics. And the council sought to ensure that the provisions are sufficiently certain to be enforceable, and that's always the most important when you're defining conditions that set the boundary between activity statuses so that someone can look at it and understand whether they comply or not. And that can be challenging when there are, the subject matter doesn't always lend itself to a specific measurement or the like, but it's important to try. And then just go on to set out what those specific changes are in 14.3, and the officers can no doubt take you through those. But 14.5, I just touched briefly on that point, that to have a provision that defaults to discretion or non-complying, the approach that the officers have taken is that they don't want that to occur simply by the triggering of one of the general standards and terms. The view is, I think quite reasonably, that to get to those statuses it should be a decision that's made quite expressly in terms of that subject matter. So there's a drafting approach there and probably a policy intent that sits behind it. And just to confirm, in terms of my whereabouts, I'm not going to be sitting here during the whole hearing, but I'll be keeping in close contact with the officers and very happy to assist as much as I can throughout the process, either with things that would be of assistance during the process or as part of the officer's reply. So please do signal to the team if there are matters that you want me to address, and I'll do that as soon as I can.
Thank you very much for that. Can I just check whether there are other legal questions which haven't come up? And Mr. Lewis, anything for you? Anything further? Just one point from me. I'll use this as an example. Section 510 in your legal submissions, it's under that avoid section, but I don't want to raise the question. It's a legal question, and then you're quoting what Ms. Palmer has recommended in terms of a policy. I just want to check it legally. This is Eco Policy 4, and the heading is provide for use and development that may impact Indigenous biodiversity, and then the rest of the policy talk about consider providing for the use. And I'm just wondering, from a legal perspective, it seems to me to be implying a slightly different test here. The policy is not directive and that provide for it if those things. It says consider, and again, this kind of is a thing that's throughout the plan. I'm just wondering, you probably haven't turned your mind to it, and again, you might want to come back, but does that imply a different test to you legally? Consider?
I think you raise a good point in terms of the connection, and it could raise a question as to whether it's meaning something more than just consider providing for. Generally, the headings should sit in behind the actual wording of the provision. It's the provision itself that's important. My suggestion on the fly in relation to that would be there's probably some value in a process of going through and testing whether some of the heading wording could be neutralised slightly. For example, that could say provision for use. In that way, the words below clearly set out the extent to which provision is being provided. But yes, I think it's always best to stick with the wording in the actual provision rather than the heading. But to the extent that there might be some discrepancy, it may be that there's an ability to go through and just do some tidy ups.
I want to put some of these questions to the planners and just whether they thought that was a different or the same, but I was interested to get a legal perspective on that.
I think in terms of if you were to test the specific question of whether provide for is stronger than consider providing for, yes it is, I think.
Yeah, okay. Thank you for that, that's very helpful. Thank you very much, that was very helpful, thank you.
Thank you.
We're going to move on to the 42A team. I just wonder, I think there is a cup of tea. I think we might just take a quick break, grab a cup of tea. We don't need to take long, or maybe we could even bring it back and we'll keep going, just take a break. Thank you everyone, just maybe 10 minutes.